The All Progressive Congress APC this Thursday closed their case in the ongoing election petition tribunal after the third respondent presented 4 witnesses who gave oral evidence. Respondent counsel told journalists that the APC decided to close their case after the petitioners allegedly failed to prove their case, saying that calling more witnesses would amount to helping the petitioners' case. BTV News senior reporter Best Orator was there for BTV News.
Shortly after announcing the appearances, Counsel to the third respondent, Chief Ferdinand Obi SAN, said on Wednesday they promised that they would exchange their schedule of documents in order to make for a seamless presentation of witnesses for the day's proceeding. He then said they were unable to do so because the documents they were expecting from Benin, the Edo State capital, did not come because without the document, they cannot progress. He, however, said they have done a further comprehensive review of the evidence led by the petitioners, the petition, the evidence elicited from their witnesses under cross-examination, the evidence led so far by the respondents in the petition with documentary evidence presented before the tribunal, and they have also considered that time is of essence and the judicial time of the tribunal is precious, adding that taking all into serious consideration, they are happy at this stage to close the third respondent's case. Counsel for the petitioners, Adetuji Oyeyikpo SAN, said they have no objection to the third respondents closing their case. Counsel to INEC, Kanu Agabi SAN, and counsel to the second respondent, Oyechikwe Asue SAN, also said they have no objection to the application for the third respondent to close their case. Chief Ferdinand Obi thereafter asked the tribunal to give the respondent 10 days for them to write their final written address, particularly as they did not take much time to present witnesses. Adetunji Oyeyikpo SAN said they will be asking for 7 days to respond to the respondent's written address. The tribunal said they need valuable time to check the evidence and law in coming to the conclusion of the matter, and they need time to consider the evidence before them, and they came to the conclusion to limit the time for all the parties to present their final written addresses. The tribunal chairman, Justice Wilfred Pochi, thereafter said that the respondents have 7 days to file their final written address, then the petitioners have 5 days to reply, and 3 days by parties to reply on point of law. Spokesperson for the petitioner, Ogbede Falu-Isibo, said even with the 4 witnesses the respondents presented on Wednesday, they as petitioners have proven their case of overvoting, as the respondent's witness proved that there was overvoting in the election, and expressed the belief that the tribunal will overturn the election results in favor of Dr. Asue Ighodalo. On his part, a member of the legal team of the third respondent, Henry Bello SAN, APC State Legal Advisor Stephen Okoro Esquire, and the state party chairman of APC, Imperial Jared Tenebe, said calling more witnesses would amount to whipping a dead horse, as the petitioners only presented incompetent witnesses and dumped materials in court without proving their case. They said the petitioners have nothing to show that the September 21 Edo governorship election recorded irregularities.
Well, the third respondents ended their matter today. They didn't call any witness today, but instead closed their case because they felt they cannot go and do the case or the petition for the petitioners. I also want to state categorically that when a petitioner is challenging the legality of an election or no substantial compliance with an election, you call polling unit agents. You call every witnesses from the polling agents or for the polling units. You call witnesses from that. Now, in this case, the petitioners were challenging 765 units out of 4,519 units, which represents 17.6% of the entire unit in Edo State. Now, out of the 765 units they are challenging, they only called 5 polling unit agents. And they could not prove their case. Now, what do you want the court to do? The court should perform magic for you? It's not possible. It's not possible because the court is not Father Christmas. They refuse to call witnesses, vital witnesses. Instead, what did they do? They calling ward unit agents, local government unit agents, and when they were asked during cross-examination, they said, they said that these results were given to them, information were passed to them from the ward unit, local government units, and that these are hearsay. Now, what do we need to do? We don't need to go and prove the case for them. We can't prove their case for them. They have the onus to prove their case, and it is going to be beyond all reasonable doubt, which they have refused. You said you are challenging 765 units out of 4,519. See, the public should also understand that they should forget about the social media reports they are getting. They are not here. They are not here to hear what the court is saying. If you look at the court is a narrow room that will not contain a lot of people. So where are they getting the information from? That I tell you for free that this petition died on arrival.
Close our case today because you know that we have very seasoned senior lawyers, and haven't assessed the evidence of PDP, and they were supposed to call about 150 witnesses. They were only able to call just 19 witnesses, and I'm sure our lawyer believed that instead of helping them in their case, they decided to close their case because the evidence they brought up also as better than our case. So there was no need to call witnesses. You know, they brought beavers to court and they dumped beavers. They brought documents to court, they dumped all the documents, about 1,000 documents. So like I said earlier on before, I said what PDP did was to bring documents to court and dump. They subpoenaed INEC to bring documents, to bring papers to dump in court. So that amounted to dumping. So I think this case is looking very, very good. And they've adjourned for final addresses. And I'm sure our seasoned lawyers are already working on that, and they will meet up with the time.
The damage has already been done. And he who fights and runs away lives to fight another day. The APC had told us, the third respondent in this case, that they had 28 witnesses to tender before the tribunal. And the 4 of them that were brought yesterday helped our case to substantiate our prayers that there was overvoting and there was non-serialization of sensitive materials. And there's a sense in which the councils saw that the witnesses were helping the PDP and decided not to call any more witnesses. They also told us that they had more documents to tender before the tribunal today. And it appears that the documents had an accident along the way, and so they couldn't bring it before the court. So we are pleased. The court, in her wisdom, has granted them 7 days to send their briefs to the petitioner, and we have 5 days to respond. And so we're hopeful that with all the evidence tendered before the courts, with all the witnesses that have come to give their addresses before the courts, the PDP has again shown to the tribunal, just the same way we have been telling the Edo people, that Asue won the election. We had the highest number of legal, lawful votes, and he should have been declared winner after the September 21st elections. So we are pleased with the outcome of the tribunal, and we are hopeful for better days ahead for the PDP.
Today we close the case of the third respondent. We have placed before the tribunal all the documentary and oral evidence requisite for the prosecution of the election petition and defense of the petition indeed. These have been ascribed to all parties in consonance with paragraph 46 of the first schedule of the Electoral Act for us to file our respectful addresses. The respondents will start first, since we called the evidence. We'll be given 7 days. The petitioners will therefore have 5 days to respond. The respondents will have 3 days to reply on points of law.
The tribunal adjourned to 3rd of March 2025 for the adoption of final written address. Relevant sections of the Evidence Act says that the burden to prove an allegation or a petition lies on the petitioner. And in this case, the burden to prove alleged irregularities in the September 21 Edo governorship election squarely rests with the petitioners, and it cannot be shifted to the respondents. For example, in the case of Abubakar and Yaadua 14, the Supreme Court said a petitioner contesting or challenging the legality or otherwise of the vote cast must be able to tender evidence and necessary evidence to prove the case. The petitioner must call witnesses to testify that the irregularities or unlawfulness substantially affected the result. And also the witnesses must be an eyewitness. They must be witnesses who observe what happened on the day of the election and should not pick evidence from an eyewitness, meaning that they must be eyewitnesses themselves. Consequences is that every allegation of non-compliance must be proved unit by unit by tendering relevant electoral documents evidencing infractions and calling witnesses who witnessed the infraction at the polling unit to give evidence in the matter. In this petition by the People's Democratic Party, the petitioners called PW1 to plead PW19, that is 19 witnesses. In the 19 witnesses, some of them were local government coalition agents, others were ward agents, and 5 of them were unit agents. If the Supreme Court judgment in the case of Abubakar and Yaradua is anything to go by, there is more to expect from the tribunal in delivering the judgment in this petition. From the National Judicial Institute venue of the Edo State Governorship Election Petitions Tribunal sitting here in Abuja, the nation's capital, Best Orator reporting for BTV News.